Hello, this is Professor Helen Xanthaki. I'm a professor of law at UCL and I specialize in legislative drafting. I would like to present to you my new book published by Eldgar a few weeks ago in 2024, Legislative Drafting for the EU, Transposition Techniques as a Roadmap for Better Legislation and a Sustainable EU. A little bit about the book. Well, basically, the book started as a way of injecting legislative quality to transposition legislation. So it started as an attempt to guide legislative drafters, national legislative drafters, on how to transpose EU legislation into national law, with an emphasis on legislative quality. It did that, but in doing so, it also revealed the weaknesses of EU acts and thus embarked on recommendations for a reform of the drafting style of EU legislation as a means of facilitating transposition and injecting effectiveness, quality into EU acts and, in consequence, transposition legislation as well. I applied and tested those recommendations on two representative sample EU acts, one regulation, one directive, thus showcasing how each of these two main legislative tools can be reformed from the point of view of their style without touching the words that are used, to showcase exactly what it is that I am proposing. And then the question, of course, arose, okay, so academically and theoretically, this is perhaps a good idea, but how can you actually introduce it in practice? And then the book basically revealed the great benefit of a user-focused, effective legislative reform could bring with it for the sustainability and longevity of the EU. So that's it in a few words. How exactly did I come about all of this? So first of all, we have to agree that good law is effective legislation. And this is not new for those who have read my previous work or those who have followed the EU's better regulation agenda from 2010 onwards. So we're looking for legislation that is effective. In other words, it is conducive of contributing to regulatory efficacy, in other words, to the production of the desired regulatory results. So how can national drafters introduce good transposition laws, keeping in mind that effectiveness is the aim and the definition of legislative quality? The way to get there is by use of Thornton's legislative drafting stages. And in stage one, national drafters need to understand the EU legislative text and, of course, the parameters of transposition. But this is quite a difficult task as things stand, because at the moment there's a lack of clear and open definition, setting of the desired regulatory results at the EU and national levels. It all comes either without an objectives clause or with very general political statements, for example, the creation of a freedom, security, and justice that are unhelpful for the drafters. And of course, any guidance or any text comes in the form of a late draft. So drafters do not get an information on what it is that the EU is trying to achieve. It is simply given as in the form of a ready-made text, a lay draft. And one does not need to be an expert in legislative studies to understand how much this is against any model for good legislation. Lay drafts are an anathema in my field of legislative studies. So what can the EU do to counteract those disadvantages? It needs to view legislation, but also the preparation of drafters in a completely different way. first of all, a revamp of the currently used introductory report and transposition guidelines to basically include drafting instructions for drafters. So reference to the EU regulatory results, apportionment of those to the national level, concrete and measurable effectiveness criteria for the EU text, apportionment of those to the national level, and the type of data to be collected for post-legislative scrutiny, which we have already in many EU instruments. For me, also, the use of sunset clauses in EU legislation can be noted as good practice, and it is something that needs to be replicated at the national level with transposition legislation. Moving on to the second of Thornton's legislative drafting stages, analyzing the proposal. And here, national drafters need to compile a legislative plan, a research report for the implementation of the EU instrument. But here is another inherent problem. There are two different sets of environments, two different sets of reports that can be introduced, one with reference to the EU legislative text and another with reference to the national legislative text. I'm reminding you that according to Thornton, the legislative report should include an analysis of the existing law, an analysis of the necessity of legislation, an analysis of the potential danger areas, policy options, the preferred legislative solution, analysis of any practical implications, but all these differ between the EU and national contexts. They do not coincide. I would say they do not necessarily coincide, but in my view, they very rarely do. And so it is quite important for the EU to draft with transposition in mind, not theoretically, but in practice. So it would be necessary for the introductory report to the EU instrument to give answers to the 7 questions of my effectiveness test. So what are the EU's desired regulatory results? What are concrete measurable effectiveness criteria? What is the regulatory deadline? What is the mischief at the EU level? What is the link between the EU text and the mischief? Any language choices in relation to users? Any guidance on national terminology. So instead of sweeping those under the carpet with, I would say, the benevolent excuse that the EU does not want to interfere with national legislative processes, it is important for the EU to set the transposition task off with a really learned, really concrete, evidence-based analysis of the EU legislative intervention as a means of assisting national drafters to ask the same questions at the national level and provide equally concrete evidence-based national answers. Now, Thornton's third legislative stage, designing the law, is where most of the work and the reform is necessary. It is necessary because the design of the law requires a number of bases that are not covered both at the EU or the national levels. First of all, the identification of the audiences, the legislative audiences. Who is this legislation for? And we know that at the moment, the tradition is to view EU legislation as a droit diplomatique, but it is not. Especially if one is a little bit more pragmatic and realizes that EU legislation is simply copied into the national language. And this is basically how the copy out technique is basically how most instruments are used and transposed. So it is very important for the questions to be answered and really radical, bold approaches to be introduced. First of all, who reads EU legislation? And obviously EU legislation is, at the end of the day, read by EU citizens. So the first legislative audience is lay people, those who are wondering what the rights and obligations are are introduced by means of EU legislation or the copied national instruments, how this will be implemented in practice, and this is the second legislative audience, those who do not necessarily have legal training, but have the task of actually implementing the legislation. And these would be people within national authorities, people within the regulated professions. So all those who will have to apply the legislation in practice and offer concrete processes. And finally, lawyers and judges, those who are interested in the nuances of EU legislation. The layered implementation measure, the layered approach in legislative drafting would be ideal here. And so the idea would be to design EU legislation into three parts. Part one, addressed to lay users and introducing the desired regulatory results, and of course the add-on value for EU citizens, plus the main regulatory messages. Very simple language so that the citizens can understand. Part two can be addressed to those authorities, national authorities, that are expected to administer the legislation. And here you have secondary regulatory messages, enforcement mechanisms, procedures, anything that has to do with how to apply this in practice. And then part three, and by the way, part two can remain more or less in the way that we draft EU legislation now. And then part three can be addressed to legal experts, and there you can run loose. Those of us who have legal training and are trained and have come to enjoy terminology and issues of interpretation, legal issues, deadlines, reviews, sunset clauses. All of this is the way to go ahead. And then, of course, having done all that in stage four, the composition is where national styles and choices must prevail. So here it is important for national drafters, but also the EU, to facilitate the end of what is the terror of departing from EU texts and the balancing of the need to obviously transpose fully and effectively against the need to become more creative in order to achieve the desired regulatory results. So if the choice is between using the EU terminology and the national terminology that best reflects the EU term, then the second should apply. An example would be the Victims' Rights Directives, and I'm saying this because victims has a different meaning in the diverse national orders, national legal orders. And then stage 5 of legislative drafting, verification, is where, again, a reform is needed. So here, verification should not only include internal verification with the EU, with national drafters and so forth. This should also be taken out to the public in the form of questions that are there not to tick the box of consultation, but mainly to ensure that the users, the lay users, the learned users, the legal users, they all understand what it is that the EU is pushing forward by way of a regulatory message. Now, if all of this is done, both at the EU level, which is where it all originates, and the transposition level, then this gives us concrete recommendations for regulations and directives. So for regulations, there's 12 recommendations. Shorter title, pinpointing the topic of the regulation so that it could be cited later on properly. Introduction of a table of contents as a roadmap for users. Radical culling of recitals, introduction of a new Article 1 on objectives, introducing concrete criteria of effectiveness, culling of definitions and correct use, simply in order to expand or delimit the ordinary meaning of the defined term, Use of the article on subject matter to list the main points of the act, so narrating very briefly to the citizen what it is that changes and what follows. And then, of course, a layered approach, so division of the regulation into 3 parts, as I've said before. And of course, the use of the appropriate easified language. You cannot have part 1 speaking to lay users in the same style that you use for lawyers and judges. Collection of all authorization for implementing and delegated acts in one article at the end of the regulation, so that we can figure out exactly how much is authorized for implementing and delegated acts. A citation article where you can, at the end of the regulation, where you can have the current title, and then the title at the very top will just be short and simply saying what this is all about, rather than all the other details. Introduction of review clauses in the article of entry into force. Introduction perhaps of an annex on definitions. So take definitions out of the text, put them in an annex so that the meaning is not diluted. And then introduction of an annex for notes and statement of the Commission, which will offer space for political context, for the political context of the regulation, for references to EU acts and miscellaneous topics. The same methodology can be applied in a directive, and here again you need to apply the layered approach, and directives change enormously under my proposals. So here you have Part A addressed to EU citizens, Part B to member states, Part C to lawyers and judges. Simplify the title in the same way as the regulation. In Part A, addressed to EU citizens, and this is the big difference, introduce an Article 1 on objectives with measurable criteria for effectiveness, explaining what is the regulatory aim of the directive and how this is beneficial for EU citizens. Then introduce an Article 2 on the subject matter, explaining the main mechanisms of law reform used to achieve the directives, the objectives, and then introduce an Article 3 on definitions as a hanging provision, and then straight move on to Article 4, listing all the rights awarded to EU citizens. So emphasizing what the EU offers. And then finally, an Article 5, which will detail in lay terms the direct effect of Article 4, thus explaining that the directive awards rights awarded to EU citizens directly, but emphasizing that protection must be afforded by member states. In Part 2, simply 2 articles. One with all the duties of the member states arising from the directive, and another article simply with powers, so what the member states may wish to do. The first one is exceptionally useful, and this has been proven by the example that I've used, because it identifies how many duties are imposed on the member states. And this is amazing because it simply answers the question, what is the burden of that directive to each member state? Very revealing. And then the mays, what the member states may or may not do, which is a great when there are drafting dilemmas. And it is also really, really good guidance for national drafters. And then Part C, addressed to learned users with everything else, entry in force necessarily with a review clause, and an article on addressees, which must include EU citizens, member states, and learned users. So these are the proposals from a substantive legislative studies perspective. How can they be pursued? Do we need a reform of the treaties? God forbid, no. There's no need to change the treaties, to change the drafting style. You simply follow the EU's better regulation agenda with its appropriate methodology. So you start with a decide test, you initiate the reform by means of the Quality of Legislation Directorate, validated from the lead commissioner, the vice president, and first vice president of the commission, and you continue on the basis of the better regulation methodology. So this can be viewed as a new legislative reform policy, and could be introduced very simply within the EU as such. But why? Why change? Why do all this? It is not as painful as treaty reform, but why on earth would you not lay a sleeping dog's sleep? Because there's a time for change. And I think both Brexit and COVID have shown very obviously that there is a need for change when it comes to the EU. The basis of the answer to the why lies with sustainable integration. Sustainable integration, in other words, advancement of the EU cause in order to achieve longevity and sustainability, is basically why we should be doing all this. But in the process, we gain quite a lot as well, because by sharing with EU citizens why the EU legislates, how it is linking the legislative text with the objectives to be achieved, and also by reassuring them that every 3-5 years there is going to be a review of that legislation, which will be amended if it doesn't work, you gain trust, the trust of EU citizens to the legislation, to the organization, to the ideal. And with trust comes loyalty. And that in turn is another feeder to sustainability. At the end of the day, this is what EU legislation should be: a method of direct communication from the EU to its citizens as a means of revealing with them why it regulates, and taking EU citizens by the hand to make them not pawns, but participatories in the regulatory efforts. I hope you will enjoy the book. I certainly very much enjoyed writing it, and I must confess that it was a revelation for me as well. It started as a very dry guide to how to transpose, and it ended with what seems to me to be quite a radical overhaul of the way in which EU legislation is drafted. Very much looking forward to hearing comments, to having the book reviewed. I hope you enjoyed as much as I have. Thank you.